Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, January 14th, 2025. We have a fun show for you today with a win from the Institute for Justice, a case out of the Ninth Circuit with some crazy facts about excessive fines that we'll get to in a moment. And then a case from the Fourth Circuit about a lot of our favorites here, including standing and mootness and racial discrimination. First, though, we're going to have a few updates. But the very first thing I want to do is introduce our guests today. They are Jared McClain and Andrew Ward, both colleagues of mine at IJ. How you doing, guys?
Good. How's it going, Anthony?
Hey, good. Well, I'm going to be excited to talk to Jared in a moment. Andrew, first I want to ask you, you just had a big deal, which was a argument at a state Supreme Court in Nebraska. You want to tell us a little bit about that?
Yeah, that was back at the beginning of December. Thanks for having me on the pod, as they say, by the way. And yeah, that's an economic liberty case about a guy who wants to start a transportation business. He can't do it because the existing companies told the government not to let him. We think that's bad. We sued about it. Now it's up at the state Supreme Court deciding whether that sort of thing gets like fake review or whether it gets real review.
And that's a state constitutional case, not a federal claim, right?
Correct. That is under Nebraska's constitution from 1875.
As many listeners know, that is close to my heart, those kind of claims. But another thing that's close to my heart is updating our viewers and listeners on what has been going on with cases that we've talked about in the past and, what happened to them now. So where are they now? But instead of about washed up stars from the 1980s, it's about old cases, and old meaning like 6 months ago. Now, the last time we did this update, we had a couple cases that had denied cert or denied en banc review, that kind of thing. This time, the funny thing is, I think it's a seasonal thing. So we're in January, right? The long conference at the Supreme Court was a few months ago where they kind of wash out a lot of the stuff that builds up over the summer. Then the buildup starts again and people file their cert petitions and then they get extensions for more briefing and that kind of thing. And I think right now we're in the middle of where like everyone has gotten a lot of extensions. And so the court I just saw yesterday, 27 relists from the orders that just came out yesterday at the Supreme Court, which was January 13th as we're recording this. So, basically, there's not a lot of news on a lot of the cases that have built up over the months. For example, we talked about a case way back on May 2nd, 2024, which was, may remember, it's U.S. versus Gregory Rogers. It's about a guy who was sitting in a car, and he was sitting in the passenger seat. Our friend Rob Fromer told us about this case. And it was whether he had Fourth Amendment standing to search of the car and his person. That was docketed to the Supreme Court back in November. It's currently in briefing. The response is due in a few weeks. And so no update there. And
the update is that the court will never take a Fourth Amendment case again.
Well, it's true. They did take a Fourth Amendment case this term, but it's like on, it's really like a Section 1983 damages claim. But yeah, like a true, what's the scope of a search claim they have not done in quite some time now. So a few other cases like that have built up, but I'm sure there will be a flood of updates soon in that regard. But our big update this week is out in the Ninth Circuit, where Jared has this case where in the district court, we'll say things didn't go according to plan. But then it gets to the Ninth Circuit and win on almost everything, right? So not win-win, and as far as the case can continue, and now you go back down below and the case can go forward. So this is, I don't think we've really discussed this case before on the show, but I think it's come up a couple times. It has absolutely insane facts about people charged fines for literally millions of dollars for something they didn't even do. So can you explain how this could happen in America, Jared?
Yeah, so this case takes place in Humboldt County, California, which is in the Emerald Triangle, they call it, because it was known for its weed growth. And I say was, I'm sure there's still people growing weed there, but after legalization, you no longer needed to hide in the mountains to grow your weed. And that is something that I don't think the city planners in Humboldt really anticipated. And so back in 2018, when California legalized recreational cannabis, I think that the county of Humboldt thought that that was going to be a cash cow for it because it was already a place known for cannabis growth. And it then it turned out that like the people up there don't have a ton of money. These permits are really expensive. It costs tens of thousands of dollars to get an operation off the ground. And why would you not just go down to the valley where you can grow on fertile soil rather than like unpaved mountain roads where people were doing it back when it was an illicit trade? And so Humboldt really wasn't realizing the profits from cannabis that it thought it was, and it just kept searching. And one way it did that was in 2018, they decided that any violation of the building code that relates to cannabis would go from being a $1 to $1,000 fine, over which you had 75 days to correct the error, and then you'd get a hearing before any fines would kick in, to a what they call a category 4 offense, which means it's a minimum $6,000 daily fine and a maximum $10,000 daily fine. And you no longer get 75 days to fix it. You just get 10 days and the fines kick in automatically. You no longer get a hearing before the fines kick in. So now any beat cop, any code enforcement officer in Humboldt County can go around and look for violations. Do you have a permit for that greenhouse in your yard? If you don't, he can just assume that that greenhouse contains cannabis and that you had to grade some land to build the greenhouse. And that right there, that's 3 violations. Each of those violations is a minimum $6,000 daily penalty, and those fines kick in after just 10 days.
And how much would you say like these properties are? I mean, not that this justifies it at all. I'm just wondering, how much would you say these properties are worth?
Much, much, much less. So our client, Rhonda Olson, for example, I'll probably refer back to her a lot just because her facts are some of the most egregious. But she bought 3 adjacent parcels of land in Orleans in Humboldt, which is like 2.5-hour drive through the mountains from the county seat in the middle of nowhere. She bought the land for $60,000, and 10 days later, she was accruing what added up to, I want to say $9.5 million in fines. And Rhonda reached out and she was like, "Hey, but I just bought this property. I know there's some like debris and there's some like an old bus that needs to get taken care of. I'll clean up the property, but like I didn't grow cannabis here. I just bought it. Like none of this stuff was mine." And the county's position was, well, it's still your responsibility. Someone else grew cannabis on that property and somebody else violated the building code. And the interesting thing on Rhonda's property is the person who violated the building code and the person who grew the cannabis were 2 separate people. The county acknowledged that the building code violations were committed in the 1980s by an unpermitted logging venture. And then somebody later came in and grew cannabis on the land on like the logging roads. And they said, okay, we have a building violation, we have cannabis growth, we have your ownership. Those are the 3 pieces to the puzzle that we need. But they did graciously reduce her fines to $83,000 a day. And those fines ran for 90 days. And this is after they admitted publicly that they knew that she had not done either the grading or the cannabis. So she accrued $7.47 million of fines on property that she had just purchased for $60,000.
Before she ever got a hearing.
But, oh, yes. Well, to this day, she has still not gotten a hearing.
The word excessive comes to mind.
Yeah. Yeah, so like one facet of this case is like these fines are crazy. This is an excessive fines case. And I think that's how the Ninth Circuit, as we'll get to, saw it, because the published portion of their opinion focused on our excessive fines claim. But there are just a litany of other constitutional violations baked in just in the way that Humboldt rolled out and enforced this policy. So when they accuse someone of growing cannabis, they admit in like 95% of the cases, basically, that they don't have probable cause to believe that you grew cannabis. They're just they purchased satellite data, and so they're looking at historical satellite photos of your property and trying to identify anything that might be an unpermitted structure. So they're looking down from the sky and they're like, well, that looks like it could be a building, and I don't see a permit on record. So they must have built that to grow cannabis, and in order to build it, they had to grow the land. That right there, that's 3 violations. That's $30,000 in daily fines. And they've admitted that they don't have probable cause. They said if we had probable cause, we'd get a warrant and we'd go search, but we don't, so we'll just issue millions of dollars in fines. And when they issue these violations, they don't tell you where the violation is on your property. They just tell you which parts of the code you're in violation of. And so, like, one of our clients, Ciro Glad, lives on 40 acres of property that he had also just purchased. And they're like, you have an unpermitted structure. And everything on Ciro's property is built by hand. Like in Humboldt County, they created, this is like a side tangent, but they created a 10-year amnesty period for people to come out and get their structures permitted, because they knew since the 80s everyone had been building their own houses and their own barns and their own sheds and their own greenhouses without a permit. So like basically nothing in Humboldt is permitted. And so you get this violation and you're like, one of your unpermitted buildings has cannabis in it. And you're like, well, it doesn't. So how am I to know which one I need to destroy? Because that's the only way to stop the fines, is to destroy it. But the problem is, in order to destroy it, you need to get demolition permits. And Humboldt did this funny thing where if you are accused of growing cannabis, you are categorically ineligible for permits. So you can't get the permits you need to abate the nuisance. You can't get the permits you need to demolish these supposed nuisances. You're just trapped in this situation where fines are accruing within 10 days on a structure that they haven't identified, and you're lost and you don't really know what you can do to stop the fines. And the point we made to the court was, like, the pressure is the point here. They're not actually looking to adjudicate these claims. They're not looking to make the properties any safer. What they're doing is trying to force people into these settlement agreements. And so you get hit with these 90 days worth of fines, and the county comes in and they say, hey, these hearing officers, if you request a hearing, the hearing officers, they work for us. We have never lost a hearing. And you could have your appeal. We'll give you your appeal, but you're going to lose and you're going to owe 90 days worth of penalties. You could just settle for 1 day worth of penalties, which, like in most cases, is about $30,000. And just going back to Rhonda's property, she bought her property for $60,000. So, like, the settlement is half the value of her property. Most of these people in Humboldt don't have anywhere near that sort of money. The average yearly income is like $27,000. So the run-of-the-mill settlement that they're offering is more than the average income. And along with paying this obscene amount of money, you have to waive several rights in perpetuity. So you have to sign the settlement agreement where you waive your Fourth Amendment rights forever. You often can't sell your property without the county's permission, and code enforcement can just walk onto your property from then on whenever they want and look around for other violations and fine you again. And so the point of this program is really to pressure people into settlements. And interestingly, the trial court, where you mentioned earlier we lost on every claim that we brought, the trial court acknowledged that the point of these excessive fines was just to promote speedy resolutions of claims. And that brings me to the fourth way that we think that this violated due process, which is there is no speedy resolution of claims. Our clients requested hearings in 2018, 2019, and 2020, and to this day, they've never received hearings. At the time we sued, some of them had already been waiting for their hearing for 5 years.
Is that, I'm curious, Jared, is that because there's a backlog, or is it just because they're super, like, lazy or worse than lazy on scheduling?
No, it's worse than lazy. So the claims that actually get scheduled, from as best we can tell, we allege this in the complaint. I'm mostly sure that it's true. The only claims that get scheduled for a hearing are ones where the sheriff's office has actually raided a property and found cannabis.
Hmm.
So if they have probable cause and they know they can prove their case, you get your hearing. And if they find you without probable cause and you request an appeal, they just put your appeal on a shelf indefinitely. And there's no, they tried to say that there was a backlog because of COVID, but they were still arguing this COVID backlog in 2024. And like there were only 1,200 active cases. So like, I don't know. If you do the math, I think that there had been like a couple dozen hearings out of like over 1,200 people who had been fined. And so IJ sued. We alleged 5 different constitutional violations, and that like that's putting it in a each of our constitutional violations then had like a subset. Like one of our constitutional violations was procedural due process, but we also alleged it violated due process in 5 different ways, and we alleged a substantive due process violation, and there were 2 of those. So like really we alleged probably roughly 10 constitutional violations. We said that there's inadequate notice because they don't tell you what on your properties, where the problem is on the property. They don't tell you how to fix it. If you ask for an appeal, they don't schedule the hearing. They're charging you without probable cause, and then there's immediate consequences because the fines start to run immediately, and then you're categorically excluded from obtaining any permits. So because there's these consequences, they need to have probable cause before they charge you, or they need to give you an immediate post-deprivation hearing, and they're not doing either. So they're just sticking these people in this like legal purgatory for years. So we had our PDP claim there, and then we said it violated substantive due process because they are charging people with indifference to their innocence. These charges are not attached to personal guilt, and that violates our substantive due process rights. And what they're doing that in 2 ways. The one way, like I said, is the enforcement by satellite, where they just are charging people without regard for probable cause. But the second way, which we haven't really got, I guess we've touched on it with Rhonda, but they are charging new owners for things that the prior owners had done. Basically, they're saying if cannabis had ever touched this property, the current owner is responsible for whoever put cannabis on it in sometimes in the past. And so that's our substantive due process claim. Then we had an unconstitutional conditions claim because they were coercing people into these settlement agreements when they needed permits unrelated to cannabis. So we had a client named Blue Graham, for instance, who he built his home himself. He had an unpermitted home, and he was trying to take advantage of this amnesty program and get his home permitted. And the county said, we're not giving you a permit for your home until you settle your abatement case. And so he's now facing more penalties. He has to choose. Like, I have to choose. Am I going to? They know now that my home's unpermitted because I've come forward and asked for a permit for it. And my only way to get that permit is to sign this settlement agreement under which I waive my Fourth Amendment rights in perpetuity, and I agree to pay this lump sum of money to the county. And so we had an unconstitutional conditions claim for that, and our excessive fines claims, which like the unseemly amount of fines pretty much speak for themselves. And there was a second type of excessive fines claim that we brought, which was every time they issue these notices of violation, they require you to return the land to its pre-cannabis state. And so that means destroying any building that has had cannabis inside of it, regardless of whether there's a public safety reason for doing so, regardless of the cost. It's just this building is permanently tainted. It needs to come down now. You're not eligible for a permit. And we argued because this is not a typical abatement case. This is not, there's a dangerous situation on your property and you need to remedy that. There was once cannabis, so we're going to punish you by imposing this demolition order. And so we said that that was also an Eighth Amendment violation. And then we said that this violated the Seventh Amendment as well because, as I mentioned, the county hires private attorneys to decide these cases. You don't even get to see a real administrative law judge, let alone a real judge or a jury. And so we said that it violates the Seventh Amendment as well. And we filed as a putative class action on behalf of all the people who had received these fines and requested a hearing and never gotten one. And the trial court dismissed our complaint in its entirety. He held that our claims were untimely because we didn't sue within 2 years of the law's passage, even though our clients had not been fined back then and wouldn't have had standing to sue. He held that our claims were unripe. He held that our facts were unripe, which I still haven't quite made sense of. And
They haven't happened yet.
yeah,
It's too late and it's too soon is always a fun
yeah.
1-2 combo.
It was too late. It was too soon, and the general tenor of the opinion, and I'm not just reading between the lines, was that we were liars. Nothing that we didn't have any credibility. Nothing we said was true, and the county would simply never do this. He said everything in the county's enforcement has been proportionate, non-arbitrary, even-handed, and fair, and this was at the motion to dismiss stage when the inferences were supposed to go in our favor.
It's actually almost, it's kind of like a reasonable conclusion because of how nuts the stuff that they're doing. Like, if you just went up to somebody on the street, right, and were like, do you think the government's going to fine you like $2 million for something somebody else did 30 years ago? The normal response would be like, no, that should not happen. I don't think that is happening. Is that happening?
Yeah. I would love to give him the benefit of that doubt, and maybe he just wasn't that dug in on our allegations. But in the county's motion to dismiss, they attached hundreds and hundreds of pages of records where they included emails from their, so the stuff I said, how we knew that the county knew that Rhonda Olson didn't do the grading or grow the cannabis. We know that because the county put it in emails and then attached it to their motion to dismiss.
That's an interesting litigation strategy.
It is. It really just goes.
It worked.
Yeah, it worked. I mean,
for a bit.
Yeah. They did not see any problem with what they were doing, and then they got a trial judge who did not see any problem with what they were doing. It was just like illicit cannabis growth going outside the permitting process. That's a problem, and the county needs to take a heavy-handed approach to fix it. And while these people might not have been personally responsible, they should have known better. And they said that at the trial court. The trial court agreed, and then they stood up in the Ninth Circuit, and they said the same thing. They said if you looked at that 3-story garage behind Doug and Corrine Thomas's house, you would have known that there used to be cannabis in there. And so you should have expected that you were going to get hit with $1.8 million in fines and a $200,000 demolition order.
Yeah. I mean, that's what I thought about when we bought our house.
Yeah. And so we appealed this to the Ninth Circuit, and the joke that I've made is it was a sovereign citizen style appeal because we raised no fewer than 10 questions presented, and that was with IJ's greatest minds getting our heads together and trying to figure out how we could make all of these issues only sound like 10. and we were like, we said our claims were both, they were ripe, they were timely, and the trial court just completely ignored the standard of review and didn't grant any inferences in our favor, and actually just drew conclusions of fact against us at the motion to dismiss stage. And then we said that we did state these 5 constitutional claims, and we asked for a new judge on remand because we did not think that, given the things that he said about us and our clients and the county, that he'd be able to fairly adjudge things if we went back down after the motion to dismiss. And I think what we said was, if he kicks this case on summary judgment, it's not going to look like justice. Even if maybe there's some some good reasons behind his decision. There were none behind the first one, and people in Humboldt are going to have a real difficult time believing that he's actually applying the law fairly the second time around. And um the case went pretty well at oral argument. The second question, I believe, was from Judge Paez. He asked, which of the trial court's errors did I think was the worst? And
That made you feel good, I'm
yeah,
sure.
yeah, really broke the tension. and because this case got dismissed in like May 2023, arguments in April 2024. So we spent a year of all of the press about this was, like Institute for Justice brought this nonsensical claim that the county's not doing anything wrong, and then we bring, like I said, a sovereign citizen style appeal where we look like crazy people. And so it was validating to get to the Ninth Circuit and immediately have them say, "Hey, this was pretty bad. Which ways do you think it was worse?" And so December 30th, we got a decision, actually two decisions from the Ninth Circuit. They issued both a published and an unpublished decision. The published decision was only on our excessive fines clause claim, and the unpublished then ran through the rest of our claims pretty quickly. And the top line resolution is that the trial or the Ninth Circuit agreed that our claims were ripe and that they were timely. It said probably 17 times throughout the opinions, granting inferences in the plaintiff's favor as we must. And they held that we stated claims for procedural due process, substantive due process, unconstitutional conditions, and the excessive fines clause. The only claim that we lost was our Seventh Amendment claim, which we conceded was foreclosed by Supreme Court precedent. And
that's a right to a jury trial.
Yeah, the right to a jury trial. There's some 1800 decisions and then like a 1920 decision from the Supreme Court pre-selective incorporation era that says the Seventh Amendment does not apply to the states. And so we were bringing this as a test case to challenge that and knew we would lose that. And that turned out to be the only thing that the Ninth Circuit thought we should lose.
And uncontroversially so, right? Like the standard for an unpublished opinion is like, this doesn't make any new law. Nobody needs to read this ever again because this is just the obvious answer. So that's fun.
Yeah, it's interesting that you make that point about how straightforward this should have been, because even our published decision on the excessive fines clause, I think it's like 28 pages long or so, and 23 of those are setting out the facts and dealing with justiciability, because the issue that the Ninth Circuit found most novel and interesting was the ripeness decision. So the trial court had held that you can't bring an excessive fines clause claim until you have paid the excessive fine. And we said, well, like Rhonda Olson shouldn't have to pay $7.5 million before she gets to go into court and say that this violates her constitutional rights. But there was really only one Ninth Circuit case on ripeness and Eighth Amendment claims, and it was prisoners who were bringing an Eighth Amendment claim about having to like double bunk in prison. And it was a new policy that got enacted, but it was only actually going to take effect if there was overcrowding, and the plaintiffs couldn't actually show that they were ever going to have to double bunk, just that it was a possibility. And so the Ninth Circuit dismissed it as on ripeness grounds, and that was really the only decision that was out there. And so we went to a bunch of out-of-circuit precedent that mostly all set a good standard of law, but they all came out in favor of not finding ripeness. So there really wasn't much out there actually pointing to a situation where somebody was hit with an ascertainable amount of punishment and sued before they paid it. And so, yeah, that turned out to be the bulk of the Ninth Circuit's published decision.
And that's not terribly surprising, right? Because there just isn't a lot of excessive fines law out there.
Generally, yeah.
I mean, it wasn't even incorporated against the states officially until we had our Tim's case just a few years ago at the Supreme Court. So
Well, like
all
there's
the
one merits case, right, that says that a fine that's like 20 times smaller than the fines here for doing something that actually you did is excessive when it's pretty minor, like not filling out a cash declaration.
Yeah.
So
right, the
you can see where that leads.
Bazar-Kashan case from I think 1998. Yeah, is
Yeah.
the only merits case from
Yeah.
the Supreme Court.
And yeah, and like there are maybe 3 Ninth Circuit cases applying Bajikagian, and most of them are the same case. There's like Pimentel 1, Pimentel 2. And so there's really just not much out there. But yeah, so we got the published decision on the excessive fines clause. They went through the Bajikagian factors and really had no trouble determining that these fines were excessive, in part because they're for permitting violations. We didn't even really challenge whether we didn't want to make this case about whether the government could fine someone $6,000 for violating cannabis laws. Our point was they're making every fine about cannabis, even when the permitting violation has nothing to do with cannabis. And just because you built a greenhouse without a permit, even if you did put cannabis inside, there's a separate penalty for the cannabis, and they're double counting by hitting you with cannabis level fines for building a greenhouse. And were it not for cannabis, everyone agrees that it would be a maximum $1,000 fine and you'd be able to fix it without accruing any money. And so the court ran through that, said there was no government interest to support this. It was basically a paperwork violation, and we stated an excessive fines claim. The court said it was a closer call, but I think the interesting holding for us was the court agreed with us that those demolition orders, the requirement to return the land to its pre-cannabis state, the court said that could also be an excessive fine if it was punitive and not remedial. And we alleged that this was purely punitive. It had nothing to do with whether the building was able to get a permit separate from cannabis. It was just because there used to be cannabis and it had to be destroyed. And so those were the wins on the excessive fines. There was one other, they pretty waved away the statute of limitations issue pretty quickly on the excessive fines, because the trial court had also said that we had to sue within 2 years of the law's passage, and the Ninth Circuit has already said that that's wrong. Basically, the idea was that, there's a rent control case where like a rent control provision kicked in and somebody waited 5 years before they sued over it. And the Ninth Circuit said, well, this had been affecting you the whole time. You knew that this was happening to you as soon as the law passed, and it started affecting your property interest as soon as the law passed. But this isn't unlike that. Our case is about an enforcement statute, and our clients had no reason to believe this law was going to apply to them until code enforcement showed up and applied it.
That's always an amazing argument that I know various governments make, that you need to challenge a law when it's passed, even if like you weren't born yet.
Yeah.
40 years ago when the law was passed, and that's the time to do it, which once you think about it doesn't make any sense, but for some reason it gets thrown up in court. Andrew, your thoughts about all the Ninth Circuit's fixing here? No,
I just I think for a case about marijuana, it's shocking that everyone's like not a little more chill. I don't. There's nothing. It's not legally interesting, right? Like this insanely bad behavior obviously violates several provisions of the Constitution, and like the interesting thing is that they're doing it. Like we encounter bad behavior, and it's like, yeah, their heart's in the right place, but just because the government wants to do something doesn't mean you can like take that little old lady's house and give it to Pfizer. But then there's stuff that's just like, truly, how could anyone possibly do this? Like a different one of our cases where a prosecutor was also a law clerk on his own cases. This strikes me as like more in the latter camp, that nobody could have ever possibly thought that this was okay. And yet here we are. So those are my comments as someone who's not on the case and doesn't have to be as judicious as Jared does.
This case reminds me a lot of, and Jared, you've probably thought about this, of a case I was a part of a few years ago in Charlestown, Indiana, where the city had a plan to redevelop a neighborhood, but it couldn't use eminent domain because of state law. And so they issued these fines for pretty minor. Sometimes they were more serious, but sometimes pretty minor housing code violations, and they would accrue daily and start on the first day. And those were like $50 a day, although there'd be like 10 violations, so they'd add up. They started with rental housing, but the plan was to move on to owner-occupied housing too. And we thought that was absolutely outrageous, and there was a big lawsuit that we won a preliminary stage about it, and eventually we settled, and we saved a lot of people in the neighborhood. But I mean, this is the same thing, but just taken way up, way up to the next level. The two cases combined give me, and other work we've done at IJ, just give me the realization that I think a lot of people, if you'd explain it to them, kind of think, you're like a black helicopter type of person. But it's like your security in your property or wherever you live is kind of hanging by a thread if a local official just wants to engage in bad behavior. And then if you sued them and tried to get damages or get consequences, then they have qualified immunity and all these other immunities that we also talk about here at IJ. And so the whole system is kind of just, to some extent, depends on just people being good people. And if they're not, you really need someone like IJ to come in and do a lawsuit like this, because otherwise they really can't get away with this kind of stuff.
Yeah. I mean, they did get away with it for, they started this in 2018. We're talking 7 years later. At the time we filed, I forget the number off the top of my head, but I want to say that they'd already foreclosed on about 40 properties that from people who just didn't appeal these fines. And that was 3 years ago now. And so like the county government is just going to own a lot of people's property in Humboldt because there's not a lot of media up there. There's not a lot of constitutional lawyers, and that people were just not equipped to deal with this bad behavior. And it makes me think of the importance of the Seventh Amendment claim that we still have out there and are going to try to get the court to weigh in on, because I think like we had the decision last term from the Supreme Court in Jarkissi about the Security and Exchange Commission needing to give jury rights to people that it's fining lots of money for securities fraud. And I think there was a lot of people saw that as like, okay, well, these are like bankers. They didn't really like appreciate the importance of the Seventh Amendment right applying to these out of court proceedings. But when you take it down to the local level, and if the people in Humboldt knew that they could just appeal and get a jury rather than this private law firm hired to do the county's bidding, I think a lot more people would still have their property, wouldn't have signed their rights away in these settlement agreements, wouldn't have like paid off this money. Like a lot of people's lives could have been helped if they had access to a jury.
Well,
Here.
We will see how things go now that you are remanded, and as we know, justice can take some time. So it may be some time before Jared's back here with the next appellate ruling in this case, if that happens. One funny last thing is there is so Northern California is, of course, just a huge area that most people don't even think about when they think about California. But there is a weed California, but it's not in Humboldt County. It's like way out on I-5. So when you come down in Oregon, one of the first towns you see is Weed, but then Humboldt County is like 4 hours from there. So gives you a sense of how big that place is.
Humboldt County itself is like our client to get from Rhonda's house to the Thomas's house is over a 2-hour drive, and then to get to Blue's house is another 90 minutes. All just like it takes hours and hours to traverse this county, and that was basically the county's excuse for relying on They're like, it would be too hard to do our job if we had to actually drive on these roads that we've never paved.
Of course. Well, one person who thought it was too hard to get a grant from the government ended up suing, but things haven't gone that well. So that is in the Fourth Circuit, and that's this case that Andrew is going to tell us about. And here we got some more mootness and standing, but also some racial discrimination.
Yeah, this is another case about sort of standing ripeness, mootness, as public interest litigators sometimes call that trifecta of things that's up in the way, with better, if perhaps more questionable, or still somewhat questionable doctrinal outcomes on the point. So this is Heyerholzer versus Guzman out of the Fourth Circuit, a case about the SBA, the Small Business Administration, and its like minority aid program rules. The Small Business Administration has a program where it gives aid to small businesses. You have to prove two things to get into that. You have to prove social disadvantage and you have to prove economic disadvantage. But basically, if you're the member of a racial minority or certain other things, you don't have to prove social disadvantage. The government just sort of assumes you are affected by that status. And it's a rebuttable presumption. They could, maybe if you like are Jay-Z, they would do something and not believe you. But for the most part, that's just taken as a given if you're a member of a minority racial group, not if you're white, as the client here, Marty Heyerholzer, in the wake of the Harvard decision getting rid of affirmative action, Students for Fair Admission, he goes and sues the SBA because he wants to be eligible for this program, even though he is not a member of a racial minority. The opinion tells us he is of Scottish and German descent, which sounds right given his name. And then what happens from the Fourth Circuit is kind of like at a nerdy level, kind of an interesting opinion, because my take on it is that it all didn't quite mesh together and didn't quite get the doctrine treated as seriously as it should have been. Two things happen. First is that the government says the case is moot because a different district court in a different suit has already enjoined this rule. A federal court in Tennessee said this rule is unconstitutional. You need to treat all applicants the same based on race, so nobody should be presumed to be socially disadvantaged based on race. The Small Business Administration says, in response to that, that's how it's going to do things. And so in this lawsuit, it says, well, this case is just moot because we've changed what we're doing, so there's no problem anymore. Fourth Circuit says, no, that's wrong. This case is not moot because there's not a final judgment there. This is sort of like a temporary voluntary cessation.
There was no rulemaking or anything, right?
Yeah. There's no final, like, we're just doing this for now because the court told us to. They're not bound by law to do it that way. So the court says the case is not moot. But all of that is dicta, and I'm not sure why it's in the opinion, because the court goes on to say that the plaintiff doesn't have standing. And again, for the nerds out there, right, you can address things in any order, but jurisdiction is always mandatory. But these are different subcomponents of jurisdiction. So you could still just not decide the mootness question if there's no standing to begin with.
That is a good result. I mean, from a public interest standpoint.
It's definitely doctrinally.
You wouldn't have that be moot.
Yeah, 100%. It's
definitely something for us.
It's definitely doctrinally right. Is it going to be citable since it's like obviously dicta? I don't know, but and just like unnecessary to the opinion, whatever. That it's good. It's good. Yeah, let's roll with that. It's good. It's good holding. We should get to cite it. But what the court goes on to say is that this guy doesn't have standing for two reasons: because he is not economically disadvantaged, and he's not socially disadvantaged. He's not economically disadvantaged because he's actually like pretty well off. Like his net worth is $850,000. He's been making his adjusted gross income. It's been like $400,000 over the last few years. And that he's not economically socially disadvantaged either. He has applied for this program in the past and he keeps getting rejected as not being socially disadvantaged. So really, it's not these racial preferences that are getting in his way. It's the fact that he's not qualified anyway. The problem with all that, and what Mr. Heyerholzer argued, is that that's not really the standard in these sorts of equal protection cases. The standard is that you need to be able to, like, ready and able to apply. It doesn't matter if you wouldn't ultimately get the thing. It's the discrimination itself that is the injury that allows you to go forward. So, for example, in the affirmative action cases, you don't need to know whether the student would have been admitted but for the lack of affirmative action. Like, would I get one of those last spots? Would I not? It's enough to say that, like, I was treated differently. And similarly, there are these older contracting cases on which those build saying, like, you don't have to say you would have gotten the contract. You just have to say, like, you're being treated differently. It's discrimination. And the Fourth Circuit does some, it does, I thought didn't really engage with that in the level that it required, because they go ahead and say, look, it doesn't matter that you're not in the right racial group because that's for the social disadvantage, but you still need to show economic disadvantage. Nobody gets preferences there. You're not economically disadvantaged. So you don't have this element of standing. Like, you don't have any element of standing because they all get lumped together, but there's no causation there, right? Like, you're not going to get this contract either way. But is that right under those contracting cases? I don't know, because like a black applicant with the same net worth would have had a different chance. And it's not like this is a little clearer on economic disadvantage, where it seems like he's pretty clearly not economically disadvantaged. But on social disadvantage, they say the same thing, that he's like not really able to apply because they've found that he's been found to not be socially disadvantaged in the past. But like, he has various social disadvantages. He has some disabilities. He has psychological problems. That seem to be the result of him having been in the armed forces. And like, a candidate from a different racial group would have the same chance to show social disadvantage. And I thought I'm curious for y'all's take. I thought it didn't quite, it might be right doctrinally, but it didn't grapple with it in the same level that I would have wanted. Like, a black applicant with all the same social disadvantages might have been able to show social disadvantage, but like, or maybe wouldn't, but doesn't have to. Whereas here, it seems like he's kind of on the cusp, but he doesn't, just to get out of the inquiry because of his race. So I don't quite know. It seems clear on economic disadvantage. What almost comes down, I kind of thought my intuitions came down on, like, it seems like if it's clear that you're otherwise not qualified, then there's a standing problem. But if it's debatable, it really shouldn't be. It was sort of my gut intuition. Like, in the affirmative action cases, it's like, well, if you had like a crappy GPA, we're not going to sort out whether you would have gotten in or not. You know, the racial discrimination is enough to grant standing. But if you're a baby, you're clearly not going to be admitted anyway. Of course, you don't have standing. That's not what's keeping you out of the school. But all of that rule that you have automatic standing just based on discrimination comes from Justice Thomas, who would have never allowed the squishy sort of factorial, not bright line rule that I'm proposing. So I don't know. I don't know if this is right. It seems kind of right on economic disadvantage because he's clearly not economically disadvantaged. It seems wrong on social disadvantage. But I'm not sure either of those are really reconcilable with the rule from the affirmative action cases and the contracting cases. But it feels like the outcome is half right to me. So I don't know if this is right or wrong. It feels right in part. But
Jared, can you mesh those together?
So is your sense that even after SBA changed the way they were enforcing the rule, like do you think that the court was addressing this pretend way that the rule works based on SBA's like the affidavits or whatever they submitted, or do you think they were actually still, because I didn't really take them to be grappling with the rebuttable presumption. They were kind of just like presuming it was dead.
Yeah, no, I'm not, I think they were dealing with the original claim, but just as a, like, if you got what you wanted sense, which it's true that is also what's going on now because of the injunction and the policy change. But it felt to me like they were like, even if you could, I mean, maybe not, maybe it was different on social disadvantage, but everybody has to show economic disadvantage. That part seemed right to me, that like, even if you had this presumption in your favor on the one prong, you still couldn't get through on the other.
Yeah, like if you think about the hotel case that got kicked last year.
Yeah.
The point in those discrimination cases is like the act of being discriminated against is a harm.
Right.
And at least I read this opinion pretty quickly, and so I kind of just assumed that they were saying, well, if this rebuttable presumption's gone, you're not actually being harmed anymore because you're not socially disadvantaged. and you're kind of just complaining that some people are more likely to be socially disadvantaged than you.
I think they were assuming it was still the old system.
Okay. I had a different. I was granting them I was reading with that presumption in mind, and so I think the opinion came off much differently to me.
No, and your conclusion is right because it's illogical. Because if there is a flat, absolute rule that discrimination is bad and confers injury, then it doesn't matter. No matter how crystal clearly you wouldn't qualify for the thing. But the problem is that this guy crystal clearly, not an adverb, whatever, wouldn't qualify for the thing. And that's ultimately right. Like, that's what's, I think, driving the opinion. It's bad vibes. This guy has gotten $130 million over the last 20 years in SBA grants and contracts, just not in this program, in a different program that helps veterans. The panel clearly doesn't like him. He might have not gotten the best panel for this claim. All of these are democratically appointed judges who maybe don't want to do anything further to chip away at these kinds of preferences, although, you know.
Well, yeah, I mean, it depends how you cut it. In a way, they kind of do, because, like, if the act of being discriminated against is no longer an injury, then that hurts people other than this guy.
Yeah, for
like in future
sure.
cases. But yeah, I just wanted to comment on your last point about how many SBA contracts this guy has gotten in the past, because there was a line in the beginning that was like, you can get an SBA contract because you're socially disadvantaged, or you can get it because you're a disabled veteran. And this guy's claiming that he is socially disadvantaged because he's a disabled veteran. And the whole opinion I'm reading, like, what am I supposed to do with that fact? And it's not until they get into, like, the third prong of standing where they're like, aha, you're just trying to double dip. You've gotten all of this money from the SBA because you're a disabled veteran and you're trying to become eligible for a second program and so, like, that to me felt like what was probably driving the outcome in this case.
Yeah, the overwhelming takeaway I had from this as a public interest litigator is, like, with nothing but love and respect for my fellow public interest litigators who put this case together, like, I'm not sure why this was the guy. I mean, yes, they have a very good argument based on this rule that discrimination is a per se harm, but you might have... The opinion could be leaving things out. I have no idea why this was the guy, but there are other white people in the United States who might have made better plaintiffs.
And I was very curious. You know, I haven't read the complaint. I haven't even read the briefs in this case, but maybe there is more that could have been pled. But I also was very curious on, like, how the socially disadvantaged and the economically disadvantaged rubrics actually work. So we have a lot in this opinion about the regs, what they say about what that means. But then, of course, there's how the program is actually structured, which, if this wasn't at the motion to dismiss stage, maybe we could learn a little bit more about. So when it's actually, you know, when they actually get into that, they worry that much about, you know, how much the guy made last year, or, you know, maybe if you grew up in a log cabin, right? Is it easier even if you've made a lot the last couple years? I mean, that might be true.
Yeah, like, as a pure fact matter, it might be that if this person were not white, he would have gotten this grant, but it sure looks like he wouldn't have on paper because of his extremely high, you know, top decile income in the United States.
Well, and it says, it says he has 800,000 net worth or whatever, but, you know, you can, if you buy a house and then value goes up in your neighborhood, like, you know, around Washington, D.C. or some certain parts of California, that doesn't mean you're that rich. It just means that your net worth is.
It doesn't, but it's also like the median black net worth in the U.S. is like 0. So then you get to the socially disadvantaged. But how do you do socially disadvantaged without race? I don't know. Maybe as a practical matter, it's not really a thing. No. Well,
right? It's all race.
The SBA has a very intricate system. On paper, it's not the most sympathetic plaintiff.
Yeah, I was actually intrigued a little by the description of how the SBA categorized social disadvantage, and like it kind of like it didn't just say like, are you from a super rural area, but like that's how it came off to me. It was like, do you live in an area that like doesn't have a lot of people around you where you feel like excluded from society? And so like it did like none of these programs are ever going to be perfect, but like especially it did feel like they were trying to capture more people than just race. But I guess the one thing that stood out to me with this case, and they kind of get to it in the redressability section, is we often think when we're trying to develop cases is if you win, is your client going to be better off? Are people like him going to be better off? And they kept saying like, if you win and you strike down this preference for certain racial groups, are you going to be better off? And the court said, no, you're still ineligible for this rule. Like the way I was reading the court's opinion was basically like they're saying you're trying to actively harm other people and you can't get anything out of this lawsuit for yourself. And like you don't want to bring, I don't know whether it's a pleading issue or a media issue, but like you don't want to bring cases that leave judges thinking that.
No, I don't know if it was I mean, they
Having
put in a
been on the
declaration,
bad
right?
side of a lot of complaints that I've tried to plead really carefully, I am still suspicious. I'll say that, Andrew, about the court's reading of the complaint, but I haven't actually read the complaint too. So
Yeah. And like
Yeah,
Andrew's saying, maybe they just didn't think you needed to plead economic disadvantage because they thought that it was a per se harm if you're getting it
Yeah.
on the socio
Yeah.
side.
yeah, but or maybe they would have if they could have. I don't know, man. This opinion raised a lot of questions for me based on my very specific niche job.
I think we could take from both cases that we've discussed this week that if you are in our niche job or just the wider world of law, you need to plead your complaints very carefully because there are a lot of judges who will not be very sympathetic to them, especially if you're a civil rights plaintiff's lawyer.
Yeah, that's really maybe the top line takeaway is that standing ripeness mootness is forever in the way of ever trying to hold the government accountable. I've been on the end of a absolutely insane standing ruling in the Fourth Circuit that never got fixed, and it is hard. It is hard to hold the government to account. There are a lot of doctrines that
So many.
but sometimes, as in Jared's case in the Ninth Circuit, the court absolutely does the right thing. So more of that, please.
Exactly. Amen. Well, I'd like to close this week with just a reminder what we talked about in detail last week, but we are having our 10th anniversary for Short Circuits coming up this spring. And if you live in the Washington, D.C. area or you live elsewhere and you want to travel for it, we'd love to see you, but especially if you live in the Washington, D.C. area, on Thursday, April 3rd in the evening, we are having a show/party with lots of very high-profile people doing awesome things, talking about Short Circuit, and with a live show and the law, and we got some retired judges talking about stuff. Anyway, I won't go into the details again and bore you this week, but please click the link in the show notes if you would like to RSVP, because I'm pretty sure it is going to, quote, sell out, even though it's free. But I'd like to thank my colleagues for coming on this week and talking some standing ripeness mootness. And please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.